Hi! Hello! Welcome to our channel. So, actually, alam ko nagbabalik-balik na talaga kayo dito. And thank you for continuously supporting this channel. And then, eto na, nandito na tayo sa final topic ng obligation and contracts. Diba? The remaining chapters, we will be dealing with the defective contracts. Pa-end na tayo. Pero mahalaga to. Etong topic na to, this is very important sa obligation and contracts. Okay? Parang ang hirap naman na tapos nyo na yung obligation and contracts and yet hindi nyo alam kung ano si rescissible contracts, ano si voidable contracts, unenforceable contracts, and void contracts. Okay? To give way to this topic, nag-skip tayo ng interpretation of contracts. Pakibasa na lang din para at least continuous yung pag-learn ninyo. Pero feeling ko naman, kaya nyo nang intindihin yung topic na yun, interpretation of contracts, kasi compared din naman sa topic na to, mas mahalaga talaga tong defective contracts. And so, yun. Ano pa? Ano pang hinahantay natin? Let's begin! First and foremost, gusto ko lang magbigay ng overview. Sino ba si Rescissible Contracts? When you say Rescissible Contracts, actually, valid naman talaga siya. Yung lahat ng essential requisites of a contract exist. But, for some reason, by reason of, economic injury or damage to one of the parties or to third person, like yung sa mga creditors, yung contract ay pwedeng ma-rescind. Okay, nandun yung defect niya. Yung dahil sa, by reason of economic injury or damage to one of the parties, such as lesion. Okay? Now, when you say voidable contracts naman, eto, ang status ng voidable contracts, paulit-ulit na, sinabi ko na rin siya previously in our discussion, ito ay yung mga valid until annulled. Okay? Unless there has been ratification, kasi pwede siyang ma-ratify. So, if hindi nyo naman pina-annulled yung contract, then valid yung status niya. Although, like kung may vitiated consent pala, parang pwedeng ipa-annulled or pwede rin naman ma-ratify. So, that's it. We will be discussing this thoroughly later. Baka sa next video if hindi natin siya matapos ngayon after ng rescissible contracts. And then third is yung unenforceable contracts. Eto naman, when you say unenforceable, from the word itself, hindi mo pwedeng ma-enforced unless ratified. Okay? Ang status niya, hindi siya pwedeng i-enforced unless i-ratified muna, tapos, tsaka mo siya pwedeng ma-enforced. Okay? And lastly, eto yung mga void or inexistent contracts. Eto yung absolutely null and void. Okay? Eto yung mga contracts which have no effect at all and cannot be ratified kasi void talaga siya and so inexistent. So, there are actually 4 types or classes of defective contracts, and they are arranged from the less serious to the most serious defects, okay? First, yung less serious defects lang dito is yung rescissible contracts. Next to that is voidable contracts. And then, mas defective pa kaysa sa kay voidable contracts is unenforceable contracts. And yung pinaka-defective talaga is yung void contracts. Okay? So, simulan na din natin. Let's start with Article 1380. Let's start discussing thoroughly the rescissible contracts. Article 1380 says that contracts validly agreed upon may be rescinded in the cases established by law. So, yun na nga. Ano ba si rescissible contracts? Sabi ko kanina, ito yung mga validly agreed upon. Valid naman, all the essential elements or requisites exist. Therefore, legally effective naman din. Pero, binigyan ng remedy yung isang party dahil merong economic injury or damage sa kanya or to third persons. And so, pwede siyang ma-rescind. Okay? So, yung purpose niya talaga is to secure reparation of the damage caused by a valid contract. Okay? Especially if the enforcement of that contract would cause injustice. So, ano ba ang rescissible contracts? Okay? Sabi ni Article 1381, the following contracts are rescissible. First, those which are entered into by the guardians whenever the wards whom they represent suffered lesion by more than 1/4 of the value of the things which are the object thereof. Second, those agreed upon in representation of absentees, if the latter suffer the lesion stated in the preceding number. Third, those undertaken in fraud of creditors, when the latter cannot in any other manner collect the claims due them. Fourth, those which refers to things under litigation if they have been entered into by the defendant without the knowledge and approval of the litigants or of competent judicial authority. And fifth, all other contracts specially declared by law to be subject to recession. So, Article 1381 obviously provides for cases or situations, instances, di ba? Nag-enumerate siya ng ano ba ang mga rescissible contracts. So, unang-una sa in-enumerate niya ay yung contracts entered into in behalf of wards. So, sabi, yun daw, in-enter into by the guardian, tapos yung ward, in representation of the ward tapos yung ward has suffered lesion by more than 1/4 of the value of the things which is the object thereof. Actually, mas madali siyang i-explain through an example. When you say ward, siya yung person who is under guardianship kasi nga he is incapacitated. So, usually mga minor. But then, hindi naman siya limited sa minors. Anyway, example, if si Pogi is the guardian of, say, Ganda, a minor, binenta ni Pogi ang property ni Ganda na worth supposedly is 1 million pesos. And binenta niya lang for 800,000 pesos. In that example, hindi naman mare-rescind kasi yung lesion yung lesion is actually not more than 1/4. So, hindi pa siya pasok kay paragraph number 1. Pero pag more than 1/4, say, binenta lang ni Pogi ng 500,000 pesos. So, yung lesion or the damage or injury to the party, di ba, dun kay Ganda is actually more than 1/4. So, in this case, pwedeng ma-rescind ni Ganda ang pagbebenta ni Pogi ng kaniyang property. Okay? So, alam ko, hindi ko na kailangang i-discuss yung lesion kasi na-discuss na natin siya in our previous videos. Now, kung hindi nyo pa napapanood yung mga previous videos, actually, i-advise ko rin, panoorin nyo na lang din kasi mas maiintindihan mo talaga yung obligation and contracts pag nakita mo siya as a whole. Anyway, let's proceed with the second enumerate ni Article 1381 as a rescissible contracts. Sabi doon naman sa mga contracts which is agreed upon in representation of absentees. Actually, same explanation with that of number 1. Pareho lang naman sila. In-represent doon kasi sa una, si guardian, yung nire-represent niya lang din naman yung ward. Dito, in representation naman sa absentees. Now, sino ba tong absentees? Ito yung mga person who disappears from his or her domicile and his whereabouts being unknown without leaving an agent to administer his property. Anyway, that is very legal term. But ang gusto kong matandaan nyo dito is yung rule na pag yung absentee suffers lesion by more than 1/4 of the value of the property, which is the object of the contract, it gives or it entitles that absentee the remedy of recession. Okay? So, pwede niyang ma-rescind ang contract na in-entered ng kanyang representative in his behalf pag nag-suffer siya ng lesion by more than 1/4. Same with yung paragraph number 1 nga, kay guardian in representation of his wards. Now, as a general rule talaga, lesion does not invalidate a contract. Diba? Na-discuss na rin natin previously. Pero yun ay may exceptions. And one of the exception is yung mga transactions which is entered into by the guardians on the representative ng mga absentees and then nagkaroon ng lesion. Okay? Now, let's proceed with the number 3. Itong pangatlong enumeration ng rescissible contracts. Sabi, yun namang mga contracts undertaken in fraud of creditors. Eto, pabalik-balik na rin yung concept. Well, if naaalala nyo si Action Pauliana, eto siya, okay? Diba, si Action Pauliana, yun yung if ever nag-enter ka into contracts to defraud your creditor, si creditor ay mayroong right to rescind the contract. Okay? Well, baka lang nakalimutan nyo. Sana hindi kayo makakalimutin. But anyway, naalala nyo ba yung example na if ever, hindi ko maalala kung paano ko sinabi before, but then if ever, si Pogi, may utang siya kay Ganda na 1 million pesos. Tapos, to defraud Ganda kasi ayaw niyang makuha dahil malamang nakita niya na if hindi siya makakapagbayad, mag-file ng case si Ganda sa kanya and then maaaring ma-attach or kunin yung kanyang property as payment dun sa utang niya kay Ganda. And so, ang ginawa niya, yung lupa niya ay kunwari, binenta niya kay Beauty. Although, wala lang, just is, ginawa niya na lang nila yon to defraud Ganda. And so, in that case, pwedeng ma-rescind ni Ganda ang contract between Pogi and the Beauty kasi it was done to defraud her. Okay? Pero, that is pwede lang if in the case na wala na talagang ibang paraan na makolekta ni Ganda ang utang niya kay Pogi. Kasi if meron pa rin naman, then the court will not rescind the contract between Pogi and Beauty. Okay? Kasi nga, di ba, pag binasa mo yun si number 3, ang sabi, those undertaken in fraud of creditors when the latter cannot in any other manner collect the claims due them. So, wala na talagang ibang paraan para makolekta yung utang. Then, pwedeng i-rescind ng court yung contract na in-entered ni Pogi with Beauty to defraud Ganda. Basta yung ano dito is that yung contract na yun is to defraud. Kasi kung hindi rin naman to defraud, din wala rin, okay? And then, if ever meron ding ibang property nga or ibang pambayad, so supposedly, bago pa man mangolekta si Ganda, si Pogi ay nagkaroon ng pera. Yun yung pwedeng habulin ni Ganda. Hindi na yung lupa na binenta niya na fraudulently kay Beauty. Okay? So, that's the third case. Another is, eto namang sa mga things in litigation. Pag pinasa natin, di ba, kanina? Things under litigation, if they have been entered into by the defendant without the knowledge and approval of the litigants. So, entered into ng defendant, tapos walang knowledge and approval yung mga litigants or kaya yung judicial authority. So, example, if si Pogi, he files a case against Ganda for recovery of a diamond ring. So, pending litigation, itong si Ganda, ang ginawa niya, binenta niya yung diamond ring to Beauty without the approval of Pogi or wala ding approval ng court. And so, yung sale ni Ganda ng mismong diamond ring in favor of Beauty can be rescinded. It is actually a rescissible contract. So, pwede siyang ma-rescind at Pogi's instance doon with the original litigation unless nga si Beauty acted in good faith. Well, ang gusto kong tandaan nyo rin dito aside from that is yung fact na dapat yung bagay, yung thing is under litigation, meaning merong pending case, okay? From the moment na nag-file or na-receive ng defendant yung summons, okay? From the moment natanggap ni Ganda yung summons na yun nga, may case pala na final si Pogi against sa kanya for the recovery of that diamond ring. So, that is already considered as in litigation na yung diamond ring. So, if ever binenta niya yon, that contract is rescissible. Now, fifth, doon sa enumeration ng rescissible contracts, sabi all other contracts specially declared by law to be subject to recession. So, lahat ng iba pang kontrata na specified by law to be rescissible. So, that's it. That's the enumeration for kung ano-ano ba ang mga rescissible contracts. So, hindi siya exclusive. Kasi nga, makikita mo kang number 5 yung iba pang rescissible contracts na if ever may batas na nagsabi na rescissible din siya. So, that would also be rescissible contracts. Now, let's proceed with Article 1382. Sabi, payments made in a state of insolvency for the obligations to whose fulfillment the debtor could not be compelled at the time they were effected are also rescissible. Okay? Well, this talks about premature payments made in a state of insolvency. So, meron tayong dalawang requisites. So, first, yung debtor or yung payer must have been insolvent, okay? State of insolvency nga. Hindi naman kailangan na judicially declared siya as insolvent. Pero, the debtor must have been insolvent. Tapos, second, the debt was not yet due and demandable. Kasi, di ba, pag binasa mo, for obligations to whose fulfillment the debtor could not be compelled at the time they were effected. So, hindi pa due and demandable. So, eto dapat yung dalawang requisites. So, both conditions are required para masabi natin na that is rescissible. Okay? Payment made in insolvency tapos nagbayad ka na hindi pa naman due and demandable. So, that is rescissible and hindi siya exclusive sa rescissible contracts. Kaya hindi siya kasama dun sa enumeration ng 1381. Ito talaga is rescissible yung payment, yung rescissible. Okay? Now, let's proceed with Article 1383. Sabi, the action for recession is subsidiary. It cannot be instituted except when the party suffering damage has no other legal means to obtain reparation for the same. So, yun nga. Yung recession is actually not a principal remedy. So, meaning, subsidiary. At ano ibig sabihin? Ma-avail mo lang siya if yung injured party has no other legal means for seeking redress or reparation for the damages that he has suffered. So, if the action was filed, or recession was filed dun sa contract in fraud of creditors, kasi yun nga, wala na siyang ibang makolekta para pang payment si creditor. So, and later on, ma-find out na meron pa palang iba, then hindi mag-prosper si recession. Kasi dapat wala na talagang ibang other means of collecting that amount or obligation due. Then, halimbawa din, if doon naman sa mga binenta through representatives, like yung sa guardian representing the ward or yung representative representing the absentees, then nagkaroon ng lesion, so meaning rescissible contracts. Pero if makikita na pwede pa rin naman meron ibang paraan to repair that lesion, hindi naman kailangan na i-rescind talaga yung contract, then Recession cannot take place. Okay? Yun yung ibig sabihin ni Article 1383. Subsidiary lang talaga siya. Hindi siya principal remedy na pag rescissible contracts, i-rescind natin to. Hindi. It doesn't follow na rescissible contracts, pwede na siyang ma-rescind. Kasi dapat wala talagang ibang legal remedies. Okay, so meaning si injured party has to prove that he has no other legal means or aside from rescinding that contract talaga. Okay, so that is Article 1383. Let's proceed with Article 1384. Sabi, recession shall be only to the extent necessary to cover the damages caused. So, aside from the fact na hindi siya principal remedy, subsidiary lang siya, yung extent of recession, hindi naman talaga entirely mare-rescind yung contract. It will only up to that extent na necessary para makover lang yung damages. Okay? Yung contract need not be set aside kaagad in its entirely by recession if yung damages can be covered by a partial recession. So, partial recession lang una. So, makikita mo talaga na yung policy or the law also wants to preserve or respect that contract kasi after all, valid naman yung contract na yan. Only that one party or other parties, other persons suffered damages or prejudice by the contract. Right? So, the only purpose of recession is actually either to repair the damage or to cover the damage cost. So, kung pwede naman, kung may other legal remedies naman, din as much as possible, hindi siya i-rescind. Yung contract ay hindi i-rescind. Then, if wala talaga, pero pwede namang partial, din partial lang muna. Okay? Hindi kaagad complete recession. Hindi talaga i-rescind in its entirety ang kontrata. Okay? Now, Article 1385. Recession creates the obligation to return the things which were the object of the contract, together with their fruits and the price with its interest. Consequently, it can be carried out only when he who demands recession can return whatever he may be obliged to restore. Tapos, second paragraph. Neither shall recession take place when the things which are the object of the contracts are legally in the possession of third person who did not act in bad faith. And last paragraph, in this case, indemnity for damages may be demanded from the person causing the loss. So, this provision speaks about the mutual restitution, okay? Rescission creates an obligation of mutual restitution. General rule, and makikita natin sa first paragraph, yung plaintiff or yung complainant who demands recession, dapat he must be able to return what has been received by virtue of that contract, that rescissible contract, okay? And it also includes, di ba, the fruits, pati pa nga interest ng price, kailangan i-return. Dapat you have that ability to return the things that you owe to the other party para mag-demand ka ng recession. Now, meron din naman siyang exception. And makikita natin yung exception sa second paragraph naman. Sabi dito, di ba, persons who did not act in bad faith. Yung bagay daw ay nasa possession na ng tao, legally in the possession of a third person who did not act in bad faith. So, meaning in good faith. So, if yung bagay ay nasa legal possession na ng third person who is in good faith, then hindi mo na rin makukuha yung bagay na yun from that third person. Pero take note, meron siyang requirements. First, that dapat in legal possession siya. And second, dapat hindi siya nag-act in bad faith. So, meaning in good faith siya. Pag ganyan, mahirap nang mag-rescind ng contracts, right? And so, ang sabi ni third paragraph, in such case or in this case, Indemnity for damages may be demanded from the person causing the loss. So, kasi hindi na pwede sa recession of contracts, then indemnity for damages na lang ang i-demand from that person, from that guilty person. So, let's have an example. Eto, in fraud of Pogi's creditors, then binenta niya ang kanyang lupa in favor of Ganda. Okay? Para to defraud his creditors nga, sabi ko kanina. Okay? Tapos, etong si Ganda, he already took legal possession doon sa lupa ni Pogi. And so, if no other legal means are found to exact satisfaction of the credits dun sa mga nautangan ni Pogi, yung sa mga creditor, nung naghagilap na sila ng pangbayad, wala na talaga silang makitang paraan, other legal means, except etong contract na to na binenta ni Pogi ang kanyang lupa to Ganda to defraud his creditors nga. And so, question. Kanina diniscuss natin si Action, Pauliana. We just focused on the right of the third person dun sa creditor, to rescind that contract. Pero, take note, kasi halos karugtong din to, na ang question, the sale of Pogi of his lands in favor of Ganda be rescinded? Pwede nga siyang pwede silang mag-file ng Recession of Contracts, pero mariresend ba? The answer is, it depends upon whether si Ganda was in good faith or in bad faith. Kasi, sabi nga ni Article 1385, second paragraph, babasahin ko again, neither shall recession take place when the things which are the object of the contract are legally in the possession of a third person who did not act in bad faith. So, if Ganda did not act in bad faith, then she is protected. Okay? Hindi na ma-rescind yung kontrata. At pero, if she acted in bad faith, pwede ang recession. Ma-rescind ang kontrata. Okay? The recession will prosper. Now, follow-up question. Since the creditors cannot rescind the contract, what is their remedy? Kasi hindi na nila ma-rescind if ever Ganda acted in good faith, di ba? So, yung third person who is now in legal possession of that property acted in good faith, hindi na ma-rescind. So, ano na ngayon ang remedy ng creditors? So, the third or the last paragraph provides that indemnity for damages may be demanded na lang daw. Sabi, di ba? Well, let's proceed with Article 1386. Sabi, recession referred to in number 1 and 2 of Article 1381 shall not take place with respect to contracts approved by the courts. So, eto yung mga contracts na rescissible contracts dahil in-enter into by the guardian or yung representative in favor of the ward or the absentees. Tapos nagkaroon ng lesson by 1/4 of the value of the property. So, pag ganun daw at yung contract na yun is approved naman ng courts, merong judicial approval, hindi na daw pwedeng ma-rescind, okay? Hindi magpa-prosper ang case for recession. That's it. That's Article 1386. It's as simple as that. So, let's proceed with Article 1387. Sabi naman, all contracts by virtue of which the debtor alienates property by gratuitous title are presumed to have been entered into in fraud of creditors, when the donor did not reserve sufficient property to pay all debts contracted before the donation. Tapos, second paragraph, alienation by onerous title are also presumed fraudulent when made by persons against whom some judgment has been rendered in any instance or some writ of attachment has been issued. The decision or attachment need not refer to the property alienated and need not have been obtained by the party seeking the recession. Last paragraph. In addition to the presumption, the design to defraud creditors may be proved in any other manner recognized by law of evidence. So, eto, presumption of fraud. So, yun nga. And this provision or article establishes presumptions of fraud, dalawang scenarios. First, in case of gratuitous alienations, and then second, kailan naman magkakaroon ng presumption of fraud sa onerous alienations. Alienations is yung ini-alienate mo yung property. Well, another term is siguro transfer of property from the debtor or from the owner to the other person. Nila-transfer mo, ini-alienate mo, okay? So, magkakaroon ng presumption of fraud sa, ito, first, i-discuss natin yung first paragraph doon sa mga gratuitous alienation. Di ba gratuitous pag walang exchange, kumbaga free of charge? Anyway, okay, ito. Magkakaroon daw ng presumption of fraud. Okay? Pag si debtor, hindi siya nag-reserve ng sufficient property to pay all the debts contracted before the donation. Diba? Pag binasa mo, yun yung ibig sabihin niya. Presumed to have been entered into fraud of creditors. So, magkakaroon ng presumption na it was done to defraud the creditors pag si donor ay hindi nag-reserve ng sufficient property to pay all debts contracted before the donation. Okay? Dinonate niya ang lahat. Binigay niya lahat-lahat kahit na alam niyang meron siyang kailangang bayarang mga utang. So, it is presumed na yun, yung pagbibigay mo ng property mo na yan dun in favor of that person, kahit alam mo na may utang ka pa sa iba, is fraudulent to defraud doon sa mga inutangan mo. So, example, if si Pogi, dinonate niya ang kanyang lupa to Ganda. But before that, before niya dinonate ang kanyang lupa kay Ganda, nagkaroon siya ng maraming utang. And nung dinonate niya yung lupa niya na kahit alam niyang yun na lang ang natitira niyang ari-arian, dinonate niya lahat-lahat talaga. Hindi siya nag-reserve ng enough property, enough portion of that to pay sa mga previously or previous obligations niya, which alam niya naman na magiging due and demandable eventually. So, yun. That donation is presumed in fraud of creditors. But of course, yun nga, presumption lang siya. Pwede naman siyang present ng or mag-show proof na it is not done to defraud his creditors. Pero the burden is upon that donor. Okay? So, paano pala if yung nangyari is ganito? Una, si Pogi, he made a donation in favor of Ganda. Tapos, yun nga, dinonate niya na yung kanyang property, nag-iisa niyang property in favor of Ganda. And then later on, nagkaroon siya ng maraming mga utang. And what was left as assets are much less. Okay? Wala na siyang pambayad. Yung assets niya kulang-kulang na pambayad sa kanyang mga liabilities na na-contract niya. Now, so the answer here is different, iba. Hindi pwedeng ma-rescind. Bakit? Kasi yung mga utang niya ay na-incurred after nung donation. So, meaning, Article 1387 is hindi applicable. Kasi pag tinignan mo yung last sentence ng first paragraph, di ba? When the debtor did not reserve sufficient property to pay all debts contracted before the donation. Eto, nauna yung donation bago siya nalubog sa utang. So, walang presumption actually. Walang presumption na yung donation was done in fraud of creditors. Well, yung presumption lang naman yung mawawala. So, meaning, if it can be shown pa rin later on that it was done really to defraud his creditors, then baka mag-prosper rin naman si recession case. Okay? Now, let's proceed with onerous alienation. Sa onerous alienations naman, magkakaroon ng presumption ng fraud, magkakaroon ng presumption that that transaction was made to defraud the creditors. First, pag daw ito, when made by a persons against whom some judgment has been rendered in any instance. So, meron ng judgment na na-rendered sa kanya or against whom some writ of attachment has been issued. Okay? Kung meron ng mga judgment or yun, some writ of attachment na na-issue, tapos binenta mo pa rin yung property mo. So, magkakaroon ng presumption na it was done fraudulently to defraud your creditors. Okay, let's take an example. Ganito. If after nung judgment has been rendered against Pogi, etong si Pogi, binenta niya ang kanyang property to Ganda. So, yung question is the sale presumed fraudulent? The sale is presumed fraudulent because it was made after a judgment had been issued against Pogi. Pero, kung nangyari, nabenta na ni Pogi ang kanyang property before pa yung judgment, so, walang presumption na fraudulent yun. Pero kung may judgment na, tapos binenta mo pa yung property mo, magkakaroon ng presumption na it was done to defraud your creditors. Okay? Malinaw ba? Anyway, please take note that the decision or attachment need not refer to the property alienated. Diba? Pag binasa mo, sinabi din ni Article 1387 na yung decision or yung attachment ay hindi naman kailangan nagre-refer dun mismo sa property na binenta ni mo or nung debtor or in our example ni Pogi. Halimbawa, if si creditor pala, creditor na lang pangalan niya. Creditor nag-file ng case against Pogi. And so, dahil nga debtor niya si Pogi. And etong si creditor nanalo. Okay, nagkaroon na ng judgment. After nung judgment, etong si Pogi, binenta niya ang kanyang properties to Ganda. Okay? Now, etong si Beauty, another creditor of Pogi. Kasi may utang din pala si Pogi kay Beauty. Pero hindi si Beauty yung nag-file ng case before at nagkaroon ng favorable judgment. Okay? Now, another creditor in the name of Beauty wants to rescind this contract between Pogi and Ganda. Gusto niyang i-rescind ang sale na ginawa ni Pogi in favor of Ganda. Now, Pogi and Ganda claim na wala namang right si Beauty to rescind, to interfere, to rescind their contract. After all, hindi naman siya yung judgment creditor, di ba? Si creditor nga, ibang creditor ang nag-file ng case who obtained a favorable judgment against Pogi. So, question, tama ba ang claim ni Pogi at ni Ganda? The answer is no. Pogi and Ganda is not justified dahil, yes, iba si judgment creditor kay Beauty. Pero, sabi nga ni Article 1387, yung last sentence ng second paragraph, di ba? The decision need not have been obtained by the party seeking the recession. Now, let's proceed with Article 1388. Sabi ni Article 1388, whoever acquires in bad faith the thing alienated in fraud of creditors shall indemnify the latter for damages suffered by them on account of the alienation. Whenever due any cause, it should be impossible for him to return them. There are two or more alienations. The first acquirer shall be liable first, and so on successively. So, the provision talks about the effect of bad faith noong, di ba, inalienate. To defraud the creditor, inalienate ngayon ni debtor. Tinransfer niya, binenta, or dinonate in favor of a third person yung property. Now, if that third person acted in bad faith, ano ba yung effect? Ano yung epekto sa kanya? So, Article 1388 provides for that. Okay? Well, Article 1388 first paragraph, makikita mo na kaagad na magbabayad daw, it shall indemnify the latter for damages suffered. So, magbabayad siya ng damages if hindi niya na, it is impossible for him to return. So, meaning, first and foremost, dapat isole. He must return the same if the sale is rescinded. Now, if it is impossible for him to return the property due to whatever cause, to any cause, then ang option is to indemnify the defrauded creditors. Now, take note ha, due to any cause. So, meaning kahit ha, kaya hindi niya na ma-return ang property is due to fortuitous event, magiging liable pa rin siya for indemnity of damages. Kasi hindi sinabi na pag ang nakalagay kay Article 1388 due to any cause. So, for whatever reason, bakit hindi niya na ma-return ang property, then he is liable to pay or to indemnify the defrauded creditors for damages. And yung second paragraph, talks about subsequent transfer pa rin, di ba? So, eto, if yung first transferee, okay, yung unang nakabili, naka-acquire, naka-purchase ng property which was transferred or sold to defraud the creditors, if he is in bad faith, then the next transferee is liable if he also acted in bad faith. So, example ganito. Pogi, in front of his creditors, binenta niya nga yung kanyang property to Ganda, who is also in bad faith. Now, etong si Ganda, after nung nabili niya yung property or natanggap niya yung property ni Pogi, tinransfer niya rin in favor of Beauty. Now, if later yung mga defrauded creditors filed a case for recession and the contract was rescinded, okay, na-rescind yung contract, pero yung property ay na-damage, say, nasunog, wala na, hindi na pwedeng ma-return. So, ang tanong, who is liable to pay for damages? Diba? Kasi pag hindi na pwedeng ma-return yung property, then sabi ni Article 1388, si purchaser in bad faith will be liable to pay for damages dun sa defrauded creditor. So, ang tanong, sino ang dapat magbayad ng damages? So, in this example, si Ganda ang mauunang magiging liable. Now, if hindi niya kayang magbayad for damages, then yung subsequent transferee ay magiging liable din. So, si Beauty ay magiging liable din. Because the law says that if there are two or more alienations, the first acquirer shall be liable first, and so on successively. So, if ever si Beauty na transfer niya na rin sa iba, then mauuna ding magiging liable si Beauty. If hindi niya rin kayang magbayad, then the next. Okay? And so on successively, sabi pa ni Article 1388. So, well, that's it. That's Article 1388. Let's proceed with Article 1389, the last provision for recession. Sabi, the action to claim recession must be commenced within 4 years. For persons under guardianship and for absentees, the period of 4 years shall not begin until the termination of the former's incapacity or until the domicile of the latter is known. So, meaning, from that time, from the date nung fraudulent transaction, meron kang 4 years to file for recession. Okay? 4 years yung period. Binigyan ka ng batas ng 4 years to rescind that contract. Now, in case naman dun sa mga minor, so, upon reaching minority, dun magsisimula ang 4 years. And dun naman kay absentee, sa pagbalik niya na, pag nalaman niya na binenta and he suffered lesion by more than 1/4. So, from the moment na nalaman niya, then he has 4 years from that. Well, that's it. That's Article 1389. See you in our next video. We will be discussing voidable contracts. If meron kayong hindi naintindihan, I suggest you go back to the previous discussions para mas makapture nyo ang whole of obligation and contracts. So, thank you once again, and God bless.